Okay, we are officially live on both platforms, and I'm so excited. So, by way of introduction, my name is Elizabeth. I am an employment attorney. And one of the things that I love to do is to help people win in the workplace. And what I've come to learn very quickly is that many people are in the workplace, particularly women of color, having an experience that is probably the worst, most traumatic experience that they've ever encountered. They find themselves in that situation and thereafter removing themselves from that situation and dealing with the trauma. And one thing that always is a question that always comes up is, should I sue? And the short answer is it depends. It depends on a number of things. And I'm going to talk to you about those things for you to think about it as you are living out this experience, as you are healing from the trauma that you've likely experienced in your workplace, and as you continue to flex your courage muscle to think about what is the next thing for you in the next season of your life. So, let's talk about what people typically sue for in the workplace. Number one, discrimination. What does that look like? So, the federal government provides protections to employees, me and you, individuals who are in the workplace based on certain protected classes. So, if you are in the workplace and your job has decided to promote you or fail to promote you because you are a woman or because you are Black or Hispanic or because of your national origin. Let's say, for example, that you are white presenting, but you come from Iran, right? And they don't like Iranians where you work. They've decided because you are Iranian that they're going to fire you, they're going to fail to promote you. That type of behavior is 100% illegal. You are protected against those types of behaviors. So, Title VII, as an example, is one of the umbrellas that gives you a full protection so that you do not have to worry about your manager treating you differently, firing you based on your skin color, based on the fact that you are a woman, based on the fact that you may be pregnant, based on the fact that you are Christian or Muslim or Jewish. These things are protected. Age Discrimination and Employment Act, which is the ADEH, the Age Discrimination and Employment Act, is specifically designed for individuals who are over the age of 40. So, according to the federal government, if you are 40 or older, you are old, baby. Okay. You are up there. So, according to the federal government, if you are being treated differently based on the fact that you are 40 or older, they are refusing to promote you, they are demoting you, they are firing you, they're not giving you certain assignments. That is called discrimination based on your age. What else do we have? They cannot discriminate against you based on the fact that you are a veteran. They cannot discriminate against you based on the fact that you are pregnant or you're about to have a baby. Some of you know my story. I've shared this story on a number of social media platforms, but if you are not aware of it, this is what it is in a nutshell. I was working for a job as an attorney. I shared with my boss that I was pregnant. They interviewed me. I found out I was pregnant 4 days later, unplanned. Actually, it was like 2 days later, completely unplanned. And yes, I was on birth control. Once I told them immediately on my very first day, which was an error. Don't do that. If you are pregnant, keep that to yourself. I told her immediately, and my manager said to me, I've never been pregnant, thank God, but you're not going to have a problem. When I got to the 12-week mark and I started to share the fact that I was pregnant, she began to act crazy. She began to bully me. She was slamming doors. She was yelling. The work that I was doing, which was not problematic, suddenly she was having problems with it. She was slamming on she was acting legitimately crazy. I was experiencing so much stress. I really and truly so much stress. I would literally go to work with my hands shaking on the steering wheel, driving to work, and it got so bad to the point. And let me tell you what she said before I tell you how bad it got. She said to me, people would ask me, "So, do you think you're going to have a boy? Do you think you're going to have a girl?" And I was like, "I don't know." And I would talk to people about being pregnant because that's how women roll. And she came to me and said, I would not let people know that you are pregnant. And she said, you have options. And I was looking at her dumbfounded because I really had no idea what she was talking about. She said, there are some clinics that will take you up to 16 weeks, up to 18 weeks. So if you need me to, I will go with you to a clinic and afterwards I will buy you a Coke. I was befuddled. I was confused and I was hurt. I ignored her recommendation. She basically recommended that I have an abortion. I ignored her recommendation. And after ignoring her recommendation, that's when she started turning up and acting extra crazy. It got bad to the point that I went to court one day and she also had a few hearings in front of the judge. So I was representing on some cases, she was representing on some cases. I was just wrapping up and she saw me. She asked me to go to the hallway with her, and we are still inside the courthouse, okay, just outside of the courtroom. And this woman is asking me information about cases. I did not have the information readily in front of me because I didn't have the files in front of me. She started to get closer and closer to me physically and began to put her hand in my face. And I was completely overwhelmed. And I saw people walking by watching this, and I was mortified. I was embarrassed. And people always ask me, why didn't you just punch her in the face? The reason why I did not punch her in the face is, number one, my default is not to hit somebody just as a person. That's not my default. But number two, you have to think about the situation the way it was set up. Here I was, a pregnant Black woman with, although she is Hispanic, she is a 100% white passing blonde, lily white alabaster woman, with this woman standing in front of me. And if I, as someone who experienced a lot of microaggressions in the workplace and in court, I would go to court, people would think I'm the defendant. I'm like, I'm not the defendant, I'm the attorney. So set the scene up in your mind. Imagine this woman is in my face doing all these extra read all about it. And if I was to push her or to strike her or to do anything, I would have been the one who ended up in jail. I would have been the one to experience injustices. So, what I decided to do in that moment, I said, enough is enough. She walked away. I walked away. I grabbed my suitcase. I went to the car. I bawled my eyes out, literally drove in tears, made it back to the office, and immediately started to pack up my stuff. As a result of that, one of the partners saw what was going on. He said, hey, can I talk to you? Because apparently she had picked up the phone and called him and was like, Elizabeth and I had some back and forths. It wasn't no back and forths. It was just her going forth. I was not going back and forth with her. I packed up my stuff. I explained to him, y'all have seen this woman bully me. Y'all have seen this woman act crazy with me. You have not done anything. And this is not good for my health. I have to go. He helped me carry myself. I got in my car. I drove home and I absolutely was a mess. And because of that situation, I now support women in particular, women of color in particular, Black women in particular in the workplace, because these sorts of nuanced experiences happen to us that many people do not actually recognize to be true. So there's a question here on Instagram that says, can you address microaggressions in emails to mass groups of people and being written up after ADA? Yes, absolutely. So let's talk about protections in the workplace. So certain things are not allowed to happen to you in the workplace based on who you are. As I mentioned, they cannot hire you because you are Black, or brown. They cannot fire you because you're Black or brown. They cannot promote you. They cannot demote you. All of these sorts of behaviors are intended to ensure that everyone in the workplace is promoted based on the work that they give. So the idea and the concept that many people are constantly pushing, you're a DEI hire if you're a Black or brown person, or you're a DEI hire if you're XYZ. All of that is not true, because the federal government literally says in Title VII, you cannot hire, promote, or do anything based on these protected classes. Therefore, there is no such thing as a DEI hire. We could talk about affirmative action a little bit later, but there is no such thing as a DEI hire. As far as microaggressions are concerned, microaggressions are one of the ways that you absolutely can prove a hostile work environment. You can use microaggressions as a means of demonstrating that you were being treated differently based on a protected class if you are suing under Title VII or under GINA, which is the Genetic Information Protection Act, or under any of the acts that I previously discussed. So, what this often looks like, if you are on an email, someone will call you out, especially if it's to the company or to a group or to your team. Someone will call you out by name and say things that are microaggressive, that are seeped in language that is rooted and it's harmful, that's often rooted in some sort of ism, classism, sexism, racism, right? So they'll say something to the effect of I am so surprised, Elizabeth, that you were able to send this out because the email was written in such an articulate way. That is a microaggression, especially towards Black women, because Black people in general, but because my audience is Black women, it is a microaggression against Black women because that language seems to push this narrative that women of color, and in particular Black women, cannot articulate themselves well. So when a person says in writing or to you in person that it is a surprise that you were able to articulate yourself or to speak so well or to do such a good job, they are microaggressing you. Now, if one microaggression happens, that does not necessarily mean that you automatically have a lawsuit. When you are looking at whether or not you have a lawsuit, what the courts will look at in particular is whether or not this behavior has been egregious enough. So if you were to go to an attorney would say, well, talk to me, what else happened? Were there any other situations? Did you object to this behavior? Did you say, I am being treated differently because I'm a woman, because I'm Black, because I'm Latina? What did you say specifically? So let me answer this question. She put in writing, you don't have to respond. Please stop doing this. You should never. Should never what exactly, Creole lady? What was she asking you not to do? All right. So when you put an ADA request in, to your original point, when you put an ADA request in, often managers and companies feel very uncomfortable with this request. I don't understand why. It is 100% your legal right to put an ADA request in, a request for an accommodation to assist you in performing your job. For some reason, they believe that this is unduly burdensome or that there's going to be a problem that results in it. By law, companies are required to support you in fulfilling that accommodation. But what ends up happening, and this is the exception to the rule, what ends up happening is that companies will say, well, we cannot give you that accommodation because it is unduly burdensome to us. That is actually the exception. So if a person says, or a company says, hey, I would give you this accommodation, but I can't give it to you because it's gonna cost us a lot of money, or it's going to impact our operations, or it's going to debilitate us in some way, then yes, that they are absolutely allowed to say that they don't have to give you that accommodation. That said, what the courts are looking for is to make sure that because you are a woman, or because you are Black, or because you are fill in the blank, that they are not treating you differently because of these protected classes. Okay, let's see. Change the subject line for a title in an email, not picking, and wrote me up after. So I'll say this. Number one, I believe that every person that looks like me and you should get comfortable with documenting their experience. Whatever this situation is, you should document that experience 100%. You should document it. And by documentation, let me give you the breakdown of what I mean, because a lot of people are like, well, what do you mean by documentation? I mean, I need to see the who, what, when, where, and how. Not why, because people behave in ways that we don't often understand, but the who, what, when, where, and how. Specifically, what we need to see is the first name and last name, who, the first name and last name, who was copied on this email? Were there any witnesses? In what manner did this occur? When did it occur? Did it occur last Tuesday? Did it occur a month ago? What time did this occur? How? What was the manner? Was this over email? To your point, was this over email or was this in person? Was this on the elevator? Was this on a Teams chat? These sorts of details are very important for a number of reasons. Number one, it sets you up for success for telling your story. And number two, if you were to go to the EEOC and say, hey, I believe that I am experiencing retaliation because I got written up after putting an ADA request in, my performance was fine. I never had any issue with my performance. I exercised my legal right, which is to put in an accommodations request under the ADA, the Americans with Disabilities Act, and suddenly I got written up. There's retaliation. The notes that you take with you capturing the experience that you've had at this job, the experience that you've had with this person, the fact that you have been othered and been treated differently absolutely supports the EEOC with doing what? Filing a charge of discrimination. Okay, so drop your questions in the chat and I will answer them. And the manager and supervisor are friends and hired her sister. Yeah, there's a lot of nepotism. So unfortunately, depending on the industry, nepotism is allowed, but even if nepotism is allowed, what is not allowed is violating the federal law and in particular violating state laws. So if you work in a company that has over 15 people, 15 is the magic number when it comes to Americans, when it comes to age discrimination, 20 is the number, meaning the laws apply to individuals who are specifically in a company with over 15 people or in a company with over 20 people if it's for age discrimination. So if you work in a company and it has 15 people and they are mistreating you and violating federal law, you absolutely should go to the EEOC. So someone says similar situation with nepotism. I was dismissed for a fictitious reason. I'm so sorry. These sorts of behaviors happen all the time and it's not right. If you were dismissed and you believe that you were dismissed based on your skin color, based on the fact that you are a woman, based on the fact that you are disabled, based on the fact that you are over the age of 40, based on the fact that there are a number of other protections in place. I kind of touched on those at the beginning of this live. I also have a video on my Instagram page, which kind of highlights specifically the areas of protection. If you were dismissed, if it was not a real reason, you know your performance was right. If you were dismissed for any of those protections, then yes, you absolutely should go to the EEOC. Let's talk about deadlines. So a lot of people will think about a situation that happened 2 years ago. Too much time has passed. So depending on the state that you're in, you have either 180 days or 300 days. You have either 180 days. Excellent. Congratulations that you filed with the EEOC. Perfect. You have either 180 days or 300 days from what the date of the first discriminatory act. So the moment that they wrote you up, the moment that they began to berate you and treat you differently or to microaggress you, that is when the clock starts. Okay. That is when the clock starts because what often happens is a lot of people will look back and say, you know what, I should have brought that lawsuit. Yes. Yes, you should have brought that lawsuit. That doesn't necessarily mean that you want to, and I'll talk about this. That doesn't necessarily mean that you want to bring a lawsuit because a lot of people don't want to bring a lawsuit, and we have to honor that. That said, if certain behaviors are happening in the workplace and these behaviors are violating federal law, you should go to the EEOC and you have to go to the EEOC first because this is an administrative burden required in order to bring a lawsuit in federal court. State court is different. States have their own laws, and often the state laws are modeled after federal law, but there are some differences. There sometimes are different requirements. They have different payout schedules. They have different caps on the amount of money of the award itself. So it makes a difference, which is why I always tell people if you're going to go to the EEOC, you should talk to a lawyer. Do you have to have a lawyer at the EEOC? Absolutely not. Most of the time, to be candid with you, a lot of people who are attorneys will say to you, have you gone to the EEOC? And then when you say, well, I haven't gone yet, and they'll say, come back to me once you have your right to sue letter. So this is a good time for me to talk to you about what the EEOC, absolutely, what the EEOC process actually looks like. So number one, the first thing that you have to do is you have to submit an inquiry on their public portal. Okay, they have a public portal. You have to submit an inquiry. Once you submit the inquiry, they're going to schedule a call. It could be over the phone, it could be in person. They want you to go down to the office if you have a local office near you, or it could be over Zoom, right? There are different options, but they're going to schedule some time to connect with you. The investigator is going to ask you questions to determine whether or not a charge of discrimination will be filed against the company. This is why it is very important to ensure that you have your documents together. I tell women all the time, and Black women in particular, you have to document what your experience is. Don't wait until something awful has happened and you're like, I can't believe these people have played in my face. Unfortunately, if you don't take good notes, you've played in your face as well, just a little bit, right? So we need to make sure that we are capturing our workplace experiences. Once you have a conversation with your investigator, they will tell you whether or not they believe that there's enough to file a charge of discrimination or there is not enough to file a charge of discrimination. Once a charge of discrimination is drafted, you will sign it because your signature is required, and immediately the charge is filed. They will send that charge of discrimination to the company. The company will then look at this charge, and then that is when the company is going to start rolling up their sleeves, and that is when the company is going to start saying, we did not violate any laws, this person was fired because it was an org chart change, we don't have any reason to believe that we have violated the law, and they're likely going to have an attorney represent them. When you get this letter, the very first thing I need you to do is I need you to calm down. Do not panic. I need you to calm down. I need you to breathe, because what often happens, and I talk to many women every week, and in my conversations, women will say, I'm anxious, I'm uncomfortable, I'm nervous. These people have done me wrong. I don't know if I should respond. Breathe. You got to calm down. First of all, you got to calm down, and second of all, you got to put yourself in the right mental state, because if you are not in the right mental state, you are going to make mistakes. You're going to take up decisions that you should have not taken up. You're going to behave in a way that's going to be for your detriment. So after you have calmed down and after you have walk through the fact that this is happening and this is reality, what I then need you to do is I need you to look at this letter. I need you to make a copy of the letter. And with the copy, I need you to start writing in the margins or writing on it. This is not true. This is true. This is et cetera, et cetera. Whatever process you need to undergo, do it, because the truth of the matter is that they are preparing to go to war with you, and I need you to get ready to buck up as well. So Creole Lady says, I even had her ask me, how old are you? Do you have kids? How can you do this at a job? So great question. A lot of people will ask questions to get information about you. Sometimes it comes off as though they're just casually having a conversation, but the truth is that they are not casually having a conversation. They're trying to get some tea. And in them getting tea, unfortunately, many people will spill their own tea. And as a result, the information that they've used, that they've given, is now being used against them. Is it legal for them to do it? Anybody can have a conversation about anything, but is it legal for them to take your private information and use your private information against you in order to discharge you from the organization? No, they should not do that. And it's 100% ugly, and it creates a situation that nobody wants to be in. What if you have a lawyer and they are still retaliating? So if you are represented by an attorney, number one, congratulations. Number two, if they're still retaliating against you, you need to be capturing every single aspect of the retaliation. What they said, what happened, what you said in response. And then you need to update your attorney week over week. And if it's egregious, immediately send your attorney a confidential email and say, this is what has happened for this week. This excellent, good job. So what's going to happen is that your attorney is likely going to take this information and use this information in one of two ways. He or she will likely use this information in a way to get them to settle with you and to close any sort of financial gap, non-monetary gaps for you, or to use this, if you end up going to trial, to use this so that we can prove to the court that yes, there were some behaviors that absolutely violated the law. So as this behavior is continuing to go on, I'm so sorry because I know you're thinking to yourself, like, I do not want to see these people. These people are wicked. And you're likely right. So while these behaviors are going on, capture, capture, capture. Send yourself a voice note. Text yourself something, right? I text myself stuff all the time. So and so said some, and that is a bold-faced lie. And this is how I know it's a lie. Do it. You want to do this because you want to get in the habit of making sure that you are capturing what is going on in the moment as closely to the moment as possible. This is important for us as attorneys. We need to know these types of things hot off the presses once they happen, right? There's some stuff that you don't sit on. So if this is happening, capture it, put it in a document, send it to your attorney week over week. If not week over week, have a live document like a Google Drive doc or whatever, and just keep updating it. And then do a comment, flag them, and say, hey, this is the update for the week. Whatever system that you and your attorney agree to, it's going to be a good system. Okay. Let me know what other questions you all have. I'm going to drop in about 15 minutes. Okay. So we've talked about the EEOC. Once they send a charge of discrimination, this charge of discrimination document is basically going to be them saying, hey, you have violated Title VII. You have violated fill in the blank, whatever the law, specific law. You have retaliated against this employee. You have violated age discrimination. You have whatever the particular umbrella is. Afterwards, they are going to send a letter, like I talked about, and then you're going to have an opportunity to respond. If you have an attorney, your attorney will respond on your behalf using the information that you've already given them. If you do not have an attorney, this is your chance to respond. So as I mentioned to you, you're going to have this document, and in the document itself, you've made a copy and you're going to write out the situation. This is why, again, you've got to have your notes, because if you have witnesses, this is the time that you drop the names of the witnesses. So-and-so called me a blah, 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 blankety blank blank. Witness, witness, witness. I need a first name. I need a last name. I need a first name. I need a last name, right? Good morning. We need to make sure that this information is succinct. So once you have this, you need to say, this person did this. I have verification, or I have proof. This is the name. Bump, 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 bump. And you need to make sure that you do that with every single contention that they give, because they are making a contention. Honey, I need you to do the same. They are telling you that this did not happen and they have not violated any federal law. Honey, I need you to say that they have in fact violated federal law, because they have treated me differently in comparison to everybody else. They are now, whatever they're doing, whatever nasty work they're doing, right? They are doing blank and they have not done blank. So after you go back and forth with them, they've written a letter saying they have not violated the law. You have responded to say, yes, you are a bold-faced lie. You and your mama are a bold-faced lie. You absolutely have violated the law. And after that, what's going to end up happening is that your EEOC investigator is going to release what's called a right to sue letter. Once you get your right to sue letter, then it's time to get to work. This right to sue letter is one of the things that often attorneys will say, call me once you get your right to sue letter. This is what they mean. This is what we mean. So you're going to get this right to sue letter, right? Just act like this is a letter. You're going to get this right to sue letter, and the letter is going to be dated. And the letter is going to say, you now have 90 days from the date of this letter to bring a case in federal court, et cetera, et cetera. This is very important, because what often people who are not practicing attorneys often believe that you got this right to sue letter and it's wham, bam, thank you, ma'am, it's over. No, this right to sue letter is the time that we attorneys are now going to draft a complaint. A complaint is going to be filed on your behalf, but this complaint is going to be as thick as possible, as thick as we can make it, highlighting how the law has been violated. We're going to highlight they have violated Title VII. They have treated you differently because you're Black. They have treated you differently because if it's American with Disabilities Act, because you're disabled. They're treated you differently because you're over the age of 40 under Age Discrimination and Employment Act, which is ADEA. They have treated you differently on this, that, and the third. We're going to drop the facts in the case. This is, again, why you got to capture notes. Here go the facts of the case. They called her a blankety blank. They failed to give her her accommodation. They immediately wrote her up the moment that she requested an accommodation. Her performance was good. She never had an issue with her performance. We're going to put all those facts in the complaint. So we put the facts, then we're going to put the claims that we have on your behalf, and then we're going to file this case. We're going to file it in federal court, most likely in federal court, with some violations of state law attached to it as well. Okay. Once we file it, then we wait. They're going to end up sending an answer. Their attorney, who has already written something on their behalf, is going to end up sending an answer to the complaint. When they send the answer to the complaint, they're going to say, my name is Bennett and I ain't in it. I've not done anything. We've not done anything wrong. That's what they're going to say. You know, they are nothing but a lie. They and their mama ain't nothing but no lies. So when they come back and say, we have not violated no federal law, we have never, and this is what they're going to do. This is one of the things they always do. Not only have we not violated federal law, we love Black women and we have a bunch of Black women on staff. That's what they're going to say. That is not the standard. Whether they do or do not have Black women on staff is not the standard under Title VII. What it is whether or not you were treated differently based on your position and what you do in the job. So what we're looking for is let's say, for example, I don't know. Let's say you work at the bakery, right? And you're a barista. If you are at the bakery and you are a barista and they are not giving you as many hours, they are making you do all the grunt work. You were hired before everybody else. You are paid the least, right? There are some obvious discrepancies, and the way that you are treated is so different, right? It's called disparate treatment under the law. That's the actual legal terms that we use. Your treatment is so different in comparison to everybody else who is similarly situated, right? All the other baristas don't get stuck with the grunt work. All the other baristas got a minimum of 20 hours and you got 4. All the other baristas are paid, I don't know, $15 an hour and you're paid $3 an hour, whatever it is. We're going to compare. That is what we're going to do. What they're going to say is, we're only treating her differently, not because she's a woman and not because she's Black, but we're treating her differently, or brown, or whatever, fill in the blank, whatever box you check. We're not treating her differently because of these reasons. We're treating her differently because of, and they're going to come up with a reason that is called pretext under the law. We don't want no pretext. We don't got no time for pretext. We don't have time for the games. So when they answer, and your attorney, or if you're representing yourself pro se and you see this answer, what I need you to do is exactly what I told you the first time. I need you to breathe and I need you to calm down, because the truth of the matter is that their whole shtick is to mess you up emotionally, that you would say something or act out or behave in a way that's going to be detrimental to your case. All right. What you need to do is you need to breathe, and again, sit with your attorney and start strategizing and game planning. Okay. Then afterwards, you're going to go to, I'm walking y'all through a lot of details. I hope this is helpful. And share this, by the way. If this is helpful for you, share this. Thank you. Then once your attorney gets this information, your attorney's going to sit with you and they're going to say, this is what they're saying. I need the notes. I need everything that they've said. I know they're ugly and they're lying. They deserve to be under the jail, but this is what we're going to do. Your attorney's going to walk you through the strategy. When you sit down and go through the strategy, a part of that strategy is going to be what's called a discovery. Everybody goes through a discovery when you're in a lawsuit. Discovery basically means that we're going to sit down and we need to now get every single document. So all those recordings, all those papers, the time that you wrote in your journal, dear diary, these people are working my last nerves, all of that stuff, you need to have that. I keep emphasizing, because we keep playing in our faces for some reason. I keep emphasizing, y'all need to take notes. You need to capture what is going on. Don't let nobody talk to you crazy in the workplace and you just walk it off, or you pick up your phone and be like, yeah, these people are crazy. No, you need to go ahead and text yourself, record a voice note. And depending on the state that you're in, you absolutely can record somebody in a meeting without their permission, right? So what we need you to do is we as attorneys, what we need you to do is we need you to be much more vigilant and intentional about the notes that you capture. Because guess what? For those of you who have been paying attention to the TikTok streets, I can't believe I'm talking about this with y'all, but it's funny because it's true, and it's true because it's funny. Y'all know about the situation with Brene and Akira. Do y'all know about the situation with Brene and Akira? Long story short, she is someone who sued the mistress who took her man. Akira was very successful in defending her case with her lawyer, of course. Why? In part because she had 700 pieces of discovery, 700 pieces of evidence. She had screen grabs from the phone. She had videos, et cetera, et cetera, et cetera. So when I tell you you need to have your documents together, you need to have your documents together, because when it gets to the point that the defense team, meaning the team that's representing the employer, when it gets to the point that the employer is seeing all the pieces of documentation of their client acting crazy, their client calling you a blankety blank, their client treating everybody better but you, their client acting in a way that is absolutely disgusting and disturbing, what's going to happen is they're going to be like, yeah, we're not going to win this one. We want to settle. We need to settle this case. Let's go ahead and cut her a check. Let's cut him a check. Cut him a check. Cut the boy the check. Cut my boy the check, because we're looking at all of this and it's not looking pretty for us. So let me answer this question. How do I phrase being yelled at and told I was yelling for simply trying to speak? What is that considered legally? So what is the phrase for being yelled at? So you're the one who received the yelling, and they're accusing you of doing the yelling, if that's correct, Creole lady. So what you want to say is, there's not really a legal phrase to it. So what you want to say is that you were berated, because that's what it sounds like, that you experience individuals berating you, yelling at you, talking to you in a way that was absolutely disrespectful, spoke to you in a way that was harmful. You want to talk about the words that they used as well. So let's say, for example, you can say that they used a very aggressive tone with you, that they yelled at you, that the words that they used, even if the words were not harmless, how they used the words were very embarrassing and unprofessional. So you want to say that, and in you highlighting that, it's going to make sure that you demonstrate to the courts that this is how you were being treated. You're also going to say that you did not have a chance to respond. You're going to say that when you attempted to respond, that you were cut off, because it sounds like you were cut off. You're also going to say that in you attempting to provide additional information and to contextualize and to give them information that they needed, that they shut you down, that they were not open to receiving any information or any feedback. Like, tell the story. Tell it's this if it's the truth, it's the truth, and the truth needs no defense. So tell the story, and tell the story for what it was. You were having a conversation. The conversation started to escalate, not on your end, but on their end. They started to yell at you, mistreat you, berate you, and then as you were trying to defend yourself and to express in response, they suddenly were accusing you of yelling. And you need to make sure that you say that there were some false accusations. Say that there were some false accusations, because if they're accusing you of doing the yelling and the screaming, what they're doing is they're trying to paint a picture as you being the aggressive Black woman. It's the oldest trick in the book. It's the oldest of bait and switch. It's the oldest trick in the book. She was aggressive. I was concerned. I was fearful. Blah, 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 blah. She was very litigious. They use the same language over and over. So you want to make sure that you are telling the story for what actually happened. Now, that being said, if there was something that you did that you know should have not been done, or you found yourself being flustered, you can say that as well. And you should just go ahead and just own it and say, because I was so upset, and so shocked at this behavior, I found myself overwhelmed. And as she escalated her voice, I also escalated my voice. The reason why you want to do that is because, number one, you don't know if you were recorded. Number two, if there were cameras in the room that would demonstrate that you absolutely acted savage. Number three, that you don't know who they're going to call to testify on their behalf and say, oh yeah, Creole lady, whenever she would talk, she was yelling and she was acting very unprofessionally. You don't know. People who you think are your coworkers, unfortunately, they can be cowards, right? And so because they can behave like cowards, because they want loyalty in their jobs, they will lie and lie and lie and lie and wrote me up for things that they said I didn't do anything wrong. And I have the text message. Good. I'm happy you have proof. I'm happy you have proof. Excellent. Excellent. Okay, so I'm gonna wrap up. So if there are any other questions for me, so by way of introduction, for those of you who do not know me, and I shared my story at the top of this live, I experienced a hostile work environment. I experienced abuse by two crazy managers, but the first crazy manager recommended that I have an abortion. The very first time that I was pregnant, I shared it with her. That was a mistake. I should have not shared it with her, and she began to bully me for not having an abortion. And I've also experienced a work environment for where this work environment, the manager was so uncomfortable with herself. She was so insecure that in her being insecure, she, whenever I would ask a question, and for those of you all really don't know me that well, but if you look in any of my all the stuff that I have online, thank you so much. Any of the stuff that I have online, the tone that I carry is typically the same tone that I carry. That whenever I would ask a question, she began to paint me as someone who was very litigious and someone who's very difficult, someone who's very aggressive. And I'm like, it wasn't, there was no aggression. Sorry, I had a call come in. I hope y'all can still hear me. There was no aggression. So as someone who has experienced this type of environment, my heart goes out to you. My heart goes out. Sorry, y'all, I gotta go soon. My man is calling. My heart goes out to you. I will be going live again tomorrow. So please join me tomorrow and let's keep having this conversation. Follow me across all social media platforms, and I look forward to providing you with education. If you need a free EEOC roadmap, the link is in my bio. Click on it, close out that first screen, and you can download it. It's 100% free for you. I want to make sure you have what you need to win. Okay. Take care, everyone. Thank you so much. And I will catch y'all tomorrow right here on Instagram at 10:30. Take care. Bye-bye. Okay, I gotta end this live. If I can end it. Here we are.